You're dealing with substance abuse, and that's bad enough. But there's many of you out there that know a worse nightmare. You're dealing with substance abuse, and you're also dealing with a high conflict custody issue, and you're frightened. You're not sure how this is going to go. And there's many other variations of this. Dr. B 360 here, and we got something special for you today. We have a special guest. His name is Navid Moshtael. He's the principal and senior partner of Moshtael Law Firm. It's a family practice firm in Orange County, California. I'm going to bring him on right now, and he's going to answer a lot of questions. And today's program will actually apply not only to those dealing with their own substance abuse and really panicked and concerned about how custody is going to go with their children, but we're going to discuss the other side as well. What if you are that parent extremely concerned about the substance abuse and behavior patterns of the other parent? And all of us know that seeking legal assistance in this area can be costly, can be difficult, and can be traumatic on everybody involved. Let's bring Navid in and get started on this. Navid,
Hey, Doc.
thank you so much for joining us today. I really appreciate it. I think we've been trying to do this for quite a long time. You're about as busy as I am, maybe more. Let me tell folks a little bit about you. Those of you that have been watching me for a long time out there know that I really, really concentrate on giving you meaningful information. And all these years, I've turned down many interviews. I don't bring people on in terms of the behavioral therapy side. I brought one guy on over the years, Parham, therapist. Why? Because he's good at what he does. I feel the same way about Navid. I've known him for probably 5 or 6 years. We've had different professional interactions, but I will say this here right now. In the last year or so, I really, and I've dealt with attorneys for years, I recommend for everyone stay away from two professionals, doctors and lawyers, because everyone loses usually except them. But I'm going to tell you, there are times you need a professional. And what I've realized about Navid over the last year is this guy is brilliant, strategic, and has an understanding of family law and an approach to cases that I was shocked when I came to actually digest gravity of depth of his skill level. Hi, Navid, and thanks again.
You're welcome.
Uh, what we want to talk about today is substance abuse as it relates to family law. And we want to do a couple of things. One, sort of a sketched outline of what that means. But I can tell you this, most folks, I don't think truly understand what the family law attorney does and how they operate and what they need to understand. So it ends up costing them a lot of money. And in these cases, usually high conflict cases, people are worked up. They're besides themselves. They're not necessarily rationally thinking. And we're going to get into a little bit of that. And I know you can translate some of the information for us. But let's start from the big picture. Substance abuse, family law. Let's begin with this thing that I've known for quite some time. The codes, the family codes in terms of substance abuse and family law, they're California codes, but the spirit of them, the roots of them come directly from federal statutes. And the concept is the best interest of the child first. Am I correct? And can you give a little background on that just to educate us?
Sure. Keeping in mind that because my practice is a California-based practice, what I address has nothing to do with the federal statutes, right? So it's
Sure.
limited to family laws. Right. So before you get into specific discussions about substance abuse, you're going to want to look. This is going to sound a bit boring, but it's Family Code Section 3011, right? So
Yeah.
Section 3011 is the controlling section that helps define for a judge what is a judge to look at when we talk about best interest, right? So things that make sense, health, welfare, and safety, right? So that's a factor. The court can look at a history of abuse. That's actually under 3011. What does that mean? Now, we're not talking substance abuse when I say abuse under that component of 3011. We're talking more about abuse of a child, abuse of a spouse, abuse of a cohabitant. So if a parent is saying, putting their hand up saying, I want custody, the court can say, all right, well, I'm going to look at the kid's best interest. I'm going to look at health, welfare, and safety. But if there's an allegation of abuse, specifically, there's an allegation that you have abused a child, that you've abused the opposing party, meaning the other parent, or that you have actually abused your spouse, meaning you got divorced and you got remarried, or you've abused a cohabitant. That could mean, again, you're in one legal proceeding for custody, but there is, again, abuse going on in your household. That's another example. All of that could imply that the court would look into that abuse. How does the court do that? The court can require independent corroboration. So the judge has the power then, right, to appoint an expert. Example, that's under Evidence Code Section 730, right, where the court can appoint its own expert to look at did that type of abuse occur. The court might even appoint a minors counsel, right? The minors counsel, meaning an attorney for the child, might be tasked by a court to look into that component. Again, 3011, did abuse occur? What's interesting about that, by the way, is that most people don't realize that because of 3011 and its discussion of abuse, that means that in a regular custody case where you're arguing over custody, you can marshal in domestic violence evidence. Remember, we're talking abuse. Okay? Abuse of a spouse is domestic violence. So you don't need to file an independent domestic violence action to bring in evidence of domestic violence. You can actually get a finding of abuse within a regular custody case as opposed to going down the route of filing a request for a restraining order. I mean, that's a topic for another day. We're still under 3011, right?
Yes.
The court can look at the nature and amount of contact between the two parents. That's still best interest. The court can look at habitual, right, or continual illegal use of controlled substances or abuse of alcohol. So remember, I talked about abuse earlier. That was in the context of abusing, right, somebody. Think of it again as domestic violence, right? Some form of abuse. And then now we're talking about abuse of substances, right? Controlled substances, illegally abusing them. And of course, you can address that, but of course, abusing alcohol too, which again, as an expert, you can talk about what that means, right? I'm an attorney, so I don't get to define for the court what abuse of a controlled substance is other than to point out to it. Now, what is interesting also under 3011, if you read it just word for word, it even talks about the fact that let's say there's an allegation of abuse, right? Whether it's domestic violence or substance abuse, and parents stipulate, mom and dad can agree, they can reach an agreement, right? On custody. Assume for a moment one parent is accusing the other of bad conduct. That falls under 3011. But they do a deal, right? Interestingly, 3011 talks about the fact that that deal still needs to be within the best interest of the child. Let me translate that for you. A judge can say no to an agreement. So I've often had judges tell me, right, it's not just the two of you, right? At the end of the day, I must sign off as the judge. So if people try to sidestep the issue, if they make an allegation of abuse, if they make an allegations of substance abuse, and then something happens and they decide to just sweep it under the rug, right? The court can say, nope, I'm not going to approve your stipulation because 3011 says even your stipulation has to be in the best interest of the child. So that answers your question about just generally speaking, what does the court look at? The court looks at the best interest of a child. And I know you're going to talk about a little bit later about the specific code section that enables a judge then to make orders pertaining to substance abuse, but 3011 is where it starts.
Okay. Now I'm going to go back up and start from the that idea of best interest of the child. How is that defined? And from a clinical perspective, uh, I refer to something called ACEs, adverse childhood events. Now, when you dig into the real experts on issues on child development and outcomes, whether it's mental health issues or actual disease or social outcomes, when a layperson you discuss with them abuse, it's very easy. Blood on the wall, okay? Or the person is, banging dope right there in front of the kid and is clearly incapable of care. I would argue that best interest of the child and abuse, I'll give you an example of abuse that the court probably, and you can comment on me, court probably couldn't care less. If you have, let's say, a parent that overly praises the child, if you went to a world leading expert, they will tell you that's child abuse. And that kid's going to have significant problems later. Keep that in mind. And I'm also going to bring something else into, and we're asking about that whole best interest of the child. There's other issues here as well. Let's say, you know, a lot of people, when they're dealing with personality disorder and substance abuse combined, a lot of these things are not going to be necessarily on the surface. In fact, data clearly shows that most high conflict separations in child custody cases, over 85% of them, one or both parents have a personality disorder, and the impact on the child is significant. So, my question is, do parents that are dealing with, and I'm going to get back to the actual user side, but when you're dealing with this kind of subtle interpretation of abuse that's real, actual, with negative outcomes for the child and the parents, uh, how does the court treat how do you deal with something like that? A person could come to you and say, that guy's doing this, this, and this. What's your evidence? And that, so do you see where I'm going with this? And
Yeah, let me back up for a moment. I know
sure.
that I really gave you I was probably using legal language when I was talking about 3011, right? The best way, in my view, to broadly look at best interest is as follows, at least under California law. I want you to remember not everybody's childhood is the same, or maybe presuming you've had a young child and you've gone to maybe a store like Michael's and you go to the store and you buy a coloring book for your child. Presume for a moment that this coloring book has the outlines of a human face drawn on it, right? Um, However, that face does not have any descriptive features. So it's just the outlines of someone's face and maybe their neck. You can't tell if it's a man, if it's a woman. You can't tell their color. You have no descriptive features. And I'm no expert on this, but I read somewhere that, the first 7 seconds you meet somebody, you form 11 impressions of them, right? And judges, by definition, are judging us, right? They're judging litigants, they're judging attorneys. So, by the way, they are using what is on the surface as a starting point, right? So, that's all they have to go on initially. Mind you, forget about the number of cases they have to manage in the public system. That's a whole nother topic, right? So, imagine again this thing you buy from Michael's, right? And you hand it to your kid. Mommy and daddy in California, as a starting point, without any of the features, are equal. We are to start as equals, right? So both parents start as this outline of a face that we haven't drawn on yet, that we haven't painted yet, right? But as you start painting the picture, then that best interest analysis starts forming, and the court forms impressions and ends up based on the evidence granting custody to one or the other, or perhaps it's shared, right? But we start with this concept that we're equal parents. So the attorney's job or the litigant's job is to paint the picture. So best way to think about best interest, we start equal. Now, what are the things that typically are on the surface that we immediately notice? I call them red flags. Things that I think you were talking about. They're obvious. Most humans would say these are red flags. If you have committed domestic violence, granted, that's a whole, again, another topic. We have to define what the law says is domestic violence. But most of us would agree that if you take your significant other and you physically harm them repeatedly, that's a form of violence, right? Red flag. Most of us will say if you abuse a child, and, again, I'm not talking subtle, right? We're talking bad human.
Yeah.
You are repeatedly, you know, beating a child. We're not talking about, I spanked you a couple times and, we're talking very, very bad conduct, right? God forbid we're talking about sexually abusing a child. Most of us, again, if you're normal, you're going to say that's a red flag. Let's keep going. Most of us would agree that if you are abusing alcohol to the point that you cannot operate as a human, if you're drinking and driving with a child in the car, right? Again, obvious things like that. Or you're repeatedly using controlled substances to the point where you have no control of your faculties, right? Those are all red flags. So if there is a red flag, you can bet that the person with the red flags, once proven, will have their custody rights dramatically impacted, right? So that concept of we start with 50-50 starts dramatically changing if you have a red flag. It's not the end of the world for the person who has the red flag, but it all depends upon how are they going to fix their problem, right? Are they going to admit they have an issue, and how are they going to fix it? You're probably going to tell me that perhaps some people are more prone to those things than others. Maybe it's their genetic makeup. Maybe it's the way they were raised. But I tend to believe that most of us, if we go through a very traumatic fact pattern in our life, it would, most of us, it would be sufficient for us to wake up and get the help that we need. So, red flags. Then you have what I call practical limitations. So again, that 50-50 will be impacted by those red flags, but let's assume you're a good human. I want you to assume that you have no red flags, and you're going, well, then under best interest, that must mean I get 50% of my child. No, there might be practical limitations. Example, you work 80 hours a week. Should that be considered? Maybe, right? So if you're working a lot and you're not available to care for that child, presume for a moment you have a very young child, for example, should that be a basis to practically say, ma'am, sir, we recognize you love your child. However, given the age of the child, by way of example, and your work schedule at this point in time, it would not be appropriate for you to have an equal custodial schedule. But perhaps you can do a step up and move your way up. That's an
Have you
example of a practical limitation,
have
right?
you have you ever seen that?
Sure, sure. A lot of what I talk about is just based on practical experience,
Sure, sure,
right?
yeah.
Another practical limitation, distance. So people move on with their lives, right? They move on from one relationship to the next. So maybe they get divorced, they find somebody else. Maybe they live in Orange County today and decide to move to the Bay Area, which that's called a move away. That's another topic. But of course, if you factor in distance, traffic, things of that nature, you could be the best parent ever, but the court might say it's not appropriate to have a young child driven, an hour and a half one way, an hour and a half the other way. That's not okay, right? So we'll leave one parent as a primary custodial parent. So that's how I view best interest. But a lot of it is based on what is on the surface. And so if you have things as you've described that are not quite on the surface, well, how am I going to know about it? I'm no expert, right? So as a lawyer, right, I'm only looking for things that are on the surface. It's what I can notice. If I have a client that tells me, well, let's say you were my client and you go, guess what? Um, I have some training that qualifies me to tell you, Navid, that there's a lot more going on than what you see on the surface. And I'm here to tell you that the conduct and the behavior of the other parent is tantamount to abuse.
Mhm.
It may not be your classic definition of abuse, but it is abuse. By the way, what does the family code define as abuse, right? Domestic violence. The lowest definition, right? The one that is kind of the bottom line, the very bottom is number one, you are the primary aggressor. Imagine again, two people in a fight. We want to identify who the primary aggressor was. And that primary aggressor has engaged in conduct that destroys the mental calm of the person seeking protection, right? Um, which, by the way, the standard is preponderance of the evidence. That is the lowest standard. 51%, the judge has to believe that the abuse is occurring. But what you believe, right? The practice of law is not a religious experience. We don't believe things, we prove them, right? We contend and we prove through evidence. So if it's not on the surface, and I'm no expert to talk about, to identify it, and my client goes, by the way, there's something going on, and it's abuse. The way that this parent is parenting is abuse. I'm going to need an expert, because without an expert, right, how am I going to prove up that thing that is below the surface? And that's another fight. Just because I want an expert doesn't mean the court's going to give me one, because you see, an expert requires data to come up with conclusions, don't they? And then if you have a child, and presuming mommy and daddy have equal rights to that child, example, legal custody, right? If they have joint legal custody, you can't submit that child to testing without court order or the written consent of the other parent. So I could have the best expert in the world, right? Dr. Bonimod is my expert. So what? Unless I give Dr. Bonimod the right evidence and data, I won't be able to prove up the abuse that is under the surface. So I'm going to need to utilize certain tools to try to get a court order that allows me to get that expert, right? So example, that gets you into Family Code 3041.5, right, where it talks about, from recollection, you have to show things like continual, right, habitual or continual, right? Which again is on the surface. You have to do enough under 3041.5 to just get the testing, right? Because even 3041.5 from recollection is preponderance of the evidence. That's also 51%.
It
So
is.
and if you can convince a court, right, that there is either habitual, frequent, or continual illegal use of a controlled substance, right, or habitual or continual abuse of alcohol, then you are in a position for the court to give you the order for that testing to occur, at which point you can have an expert come in. Mind you, obviously, again, controlled substances and alcohol is different from the underneath the surface things that you were talking about. But anyway, that's a long enough answer. So what's your next question?
Yeah, I mean, that, no, I've known you, so you always speak like an attorney. That helps, and I think uh, uh, I'm going to save some of this. Hopefully, we do one on narcissism and personality disorders to really dig this out. And I will say that, when you're dealing with someone that has a collective behavioral manifestation that's impulsive, unpredictable, involves substance abuse, and are aware of keeping it hidden, it becomes a problem. I'll give you an example. let's say there's 30, 40 things, and two of those things I come to you and say, hey, Navid, this kid is 9 now, and he's still sleeping in the same bed with his mother. Now, mind you, I have 20 other complaints, and I can show this kid's going off the rails, maybe, and it barely reaches the surface. And to me, if someone came to me and said, a kid is 9 and he's still sleeping in the same bed with his mom, right off the bat, in fact, some experts in the world would say, I can tell you A, B, C, D, E, F, G, and he needs to be removed from that home if you want that kid to have a chance in this world. I think we'll get into that, hopefully with you some more, and get into personality disorders, which will include substance abuse and some of these other issues. Let's
By
get
the
there.
way, most judges would view the person saying that as a parent that's micromanaging, because again, judges are go based on their experience, so they're gonna that they don't have the education of that particular person. So if that's all they hear, they're gonna go, well, here's another example of somebody that's micromanaging, right? Stay in your lane, exercise your custody during your time, and stop turning something small into something big, right? That's what most judges would do.
And I was trying to get you to say this in one way, shape, form, or another. And that is a major problem because, like I said, I can bring the world leading experts on these issues. And if you said this to them, they'd be horrified, and they would actually say, they would ask a bunch of other questions, and then really, let's say they had an opportunity to evaluate that person, and they would actually, many of them, and there's maybe about 6 or 7 of them, they would say that kid needs to be removed from that home. And in fact,
Well, Doc, the problem becomes that, I just don't think that our current system is designed for that, right?
I
So
agree.
I just, the judges just don't have the time. They don't have the resources. Now start talking about, most family law litigants, right? Where are they going to get the money and the resources to go hire the expert,
I
right?
agree.
Just to prove that. And again, that's going against the grain. So imagine the likelihood even of them, even if they have the money and the expert, of trying to prove something up like that, right? Because again, most of the judges will look at them as, you're crazy. What are you trying to prove up? Right. And I'll just give you the other side of this. If everybody looked at it the way you did in that example you provided, doesn't that cause more litigation? Can you imagine the number of people that are going to now roll into court and come up with one excuse or the other as a basis to try to modify custody or, keep relitigating the same thing? Because I think there's a distinction between somebody like you who has the education and training to say something like that, as opposed to a layperson like me who doesn't have your training, right? Then I'm going to start spotting problems that may not be problems. So I'm just giving you the other side of it. There's also the thought that it might create more litigation because now we're looking for all sorts of things as a basis to say the other parent is abusing. So just a thought.
Yeah, I don't disagree there. And that's why I actually think there needs to be a complete revamp of the system and public's awareness, education. I'll tell you a great example of something like that. I always use this. And I think at one point I was having a passive chat with one of your partners, Brett. And I brought up, I said, you need to watch Johnny Depp's case. As you guys know better than me, proving what he was trying to prove, defamation is a difficult task already, and he lost it in the UK. The only what he did here was spend an incredible amount of money to get a legal team that spent that time to draw out the nuances of the insanity of the situation, and he won. And who has $10 million, right? And who has that kind of time? But I think there's a tragedy here and we'll get to this hopefully in the future, that the children suffer. And I also have some thoughts when we talk about best interest of the child, when we're dealing with this kind of thing, the other parent, the healthier one, suffers extensively in their finances, in their mental health. And it's in the best interest of the child for the healthier parent to be able to take care of their child, yet they're confronted with this kind of madness. I'll leave it at, go ahead.
Let me jump in actually. Something interesting to think about. You talked about the other parent. So let's presume for a moment we're talking about the healthier parent,
The
right?
healthier parent.
And let's say that the non healthier parent is the one that um, suffers from substance abuse or alcohol abuse and things of that nature. Um, Remember, I defined domestic violence for you.
Hmm.
So, query, are you a victim of domestic violence if you are the healthier parent, if you have repeatedly been in a toxic environment where your spouse or your significant other has abused or has abused substances or alcohol? So that's a form of domestic violence. Think about the fact pattern. If you are around somebody, right, that is habitually, frequently, or continually abusing drugs, right, over and over and over, does how you are as you being the healthier parent in that situation, are you a victim of abuse?
Absolutely.
Okay. Then why'd you stay in it?
You're talking about while you're in it?
No, no, no. I'm saying to you, imagine a family law case where, and I've had these cases, right? Where I've either defended or prosecuted a DV, right? And the DV is one parent is alleging my partner abused drugs. I've known them to abuse drugs for years in our relationship. I not only had one, two, or maybe three children with them, knowing that they abused drugs, I have experienced them going through seizures. I've had to administer Narcan or medication to them. I've had to call law enforcement, so on and so forth. And I'm a victim of domestic violence. Therefore, not only am I seeking to have substance abuse testing, right? But as part of best interest and frankly, as domestic violence, I seek to limit their rights. So that can be argued to be domestic violence, right? Because you're on the receiving end of all this bad conduct. Of course, the flip side is, again, as I said, if you've been with somebody for years and you've known them to engage in that type of conduct, the query becomes at what point would it have been appropriate for you to leave, right? Um, when was that appropriate? After the first child, the second child, the third child, so on and so forth, right? So that is a form of abuse, is being on the receiving end of someone that abuses substances. But what if that person owns up to their mistakes? You see, best interest custody it's not frozen in time. You know, we all make mistakes. So if we acknowledge those mistakes, if we clean up, right? If we get the right expert involved, we show months and months of being clean, voluntarily submitting to testing, things like that, right? Taking co parenting classes, taking anger management classes, being in therapy regularly, being even medicated to the extent it's recommended by a doctor. Should that person have a chance? Yes.
Absolutely.
Right.
And
So I don't want this to come off like, I think everybody deserves a chance if they own up to the mistakes they've made. Right. And if they convince a court that they've corrected those red flags that we talked about, right, to the point that the court can trust them slowly with that child.
I agree with you 100%. And I think what I'm doing is mixing, putting together substance abuse and personality disorders, and that's a whole different uh, 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 approach and thinking. Now, if you're talking about substance abuse, I agree with you 100%. But the person who is just dealing with substance abuse and doesn't have those other issues is going to fess up, is going to work hard. I'll give you a wonderful, amazing example of just that. I got a kid that I've been taking care of for years. And from when he was 18, now he's in his mid to late 20s. And his substance abuse got so bad, he even served federal prison time, came out. I knew him before he went into, I don't think it was federal state, but when he came out, I knew that he had reached a level of maturity and sobriety. And we were sitting in my office, and custody and children have a special place in my heart. And he reminded me that he has a small boy, 8 years old, and in the Midwest somewhere. And I said, "How often do you see him?" He's like, "Mom's got full custody. Every once in a while, I call." I told him, "Look, we'll call him Joe. Look, Joe, tell you what, unless if you seek to build a relationship with your son, I'm firing you as a patient, because I think that not only is that critical for the boy. So I am, as your doctor, no longer your advocate. I'm your son's advocate, but it's critical for your long term well being, meaning, and having a reason to live. So here we are a year later. He moved over there, got 50-50 custody, bought a house, has a job, and is full time in his kids. So I agree with you 100%. And that's substance abuse. Let's stick to that. Let's say we have, and this is where a lot of the people that watch this channel, let's say you have serious active substance abuse issues or alcohol issues, and you're in a separation and mom's going to take the kids away. Your nightmare is, and let's say California, you are a California, Orange County practicing attorney, and they're just horrified by this, and they come to you. How's this going to go? And how is the courts going to deal with this?
Sure. Um, well, number one, I typically would confidentially send them to an expert that I would hire. And so if they're admitting to me that they have an issue, um, even assuming they tell me they're clean, from my perspective, I want them tested, right? So they need, as a condition to me agreeing to represent them, right? I want them to be a good human. If they're saying I have a problem and I've cleaned up, or I have a problem and I'm going to clean up, then a condition to representing them is they clean up. So I line up an expert, a substance abuse expert, right? And I send them confidentially to that person. The reason I retain the expert is then attorney work product attaches, right? So the testing is confidential. It's not discoverable. It could be discoverable later down the line, but initially it's not discoverable. So you put them with an expert and you wait for the results, right? That's step one. And they work with that expert. Maybe that expert will refer them out to other services. But the idea is that they clean up. I have them also tested by an independent facility voluntarily, so many times, a month or a week, just so again, we can start the process of proving up that they're clean. You can clarify this because I'm not a doctor, but the substance abuse experts I've spoken to have mentioned to me that a hair follicle test, right? If you run a panel, a hair follicle, which I've also been told technically it's not called a hair follicle test, that people call it hair follicle, but it's not really. Anyway, I don't know what that is, but they refer to it, but I've been told just refer to it as a hair test, but whatever. So this commonly understood to be hair follicle test can go anywhere between 6 to 8 months, right? It can cover retroactively 6, maybe up to 8 months. By the way, it's not constitutional for a judge to order a hair follicle. However, people can stipulate to it, right? So again, if it's my client, I want them to do the hair follicle.
Can you explain that for the viewer? It's not, the judge can't order it, but the clients can stipulate to it. Can you explain
People,
that?
right, litigants in a divorce can agree, right, that they'll undergo hair follicle testing. A judge can do, basically urine, essentially, right, which doesn't capture that much. Um, of course, a judge can appoint an expert, but even that expert cannot do hair follicle unless somebody agrees. So again, I'm cleaning them up, right? Get them help, clean them up, have them regularly test. And of course, that first test is also going to tell me if I've been lied to, if they take a hair follicle, because I always ask, how long have you been clean? But that's okay. If they're not clean, we'll get them cleaned up. So typically, right? It's going to take anywhere between probably a minimum of 3 months up to maybe even 5, 6 months until we have a full blown hearing on custody, right? I'm talking full blown. So that will be enough passage of time, right? For that 5 to 6 months. Think again, hair follicle, right? We're voluntarily submitting to one that they clean up so that you can have them retested, right? Leading into that hearing so that the hair follicle can go about 6 months out and say, this person has been clean for 6 months, in addition to the regular testing that they've been doing every week. So that's something that I do, right? And sometimes I'll combo that with just therapy, right? You want to send the person to therapy so they can deal with any possible mental health issues. You just want them to be regularly going. Again, I'm no expert, but maybe people that have some substance abuse issues have some personality issues that go with it, right? So I'm going to want them to talk to a therapist about it. So that's one way that we handle it. Um, you also have to consider the extent to which, assuming there's no criminal liability tied to this, right? Because we're talking the use of illegal substances, right? Separate from alcohol abuse. So you have to consider, is your client going to admit to a crime? Because then that's a whole nother discussion that we're going to have, right? But presuming there's no criminal aspect to it, I think it's best for people to be upfront with the court, meaning admit to your historical issues and show the court that you've cleaned up.
Explain when you say criminal, just simply by telling you I use heroin. Is that a criminal attack? When you say criminal, do you mean technically a history of legal involvement, or just simply if I tell you I use heroin, I'm a heroin addict? Is that
Well, I'm not equipped to give advice on what is a crime and isn't because my practice is limited only to family law, right? So typically, what I just meant is that if we are talking, if I read the statute and it refers to the word illegal, right? What does that imply to me? That
okay?
implies to me that the law says there are certain things you can and cannot do, right? So presumably, if you've engaged in behavior that is not allowed for, I might send you to a criminal law lawyer and go, hey, before we open our mouth and go acknowledge bad behavior, let's just make sure that we're not exposing ourselves to criminal liability. So, presuming that's not the case, then you want to clean up, but you also want to own up to your historical issues, right? And well, what else do you do? Well, again, I talked about timing, but eventually you're going to want to see the judge, right? To ask the court to give you a custody order. You're going to want to fashion a custody proposal or a visitation proposal that you know your judge is going to accept, right? So presume for a moment you're admitting to substance abuse issues. You've only just gotten tested, you're cleaning up. It would not be reasonable for you to go to court and say, I want 50% custody. You haven't addressed the red flag. It's just not realistic, right? But maybe you're going to ask the court to give you a step up. I talked about that earlier, right? So telling the court, I have voluntarily tested. I am going to show you this hair follicle test. I'm going to bring the expert. So now the very expert that that I had retained confidentially is now going to be disclosed to the other side. And they're going to come in and they're going to testify for a very limited purpose. Why? Because I don't want their entire file to become discoverable, right? So remember that first test that's going to show positive. I don't want that to come out, right? I only want the one that's good to come out. So if I bring my expert that I've retained previously, you have to limit what that expert is going to talk about. So that expert is going to come in for one proposition only. As we sit here today, does this person suffer from substance abuse issues? Yes or no, right? If the answer is no, then hey, doc, what testing did you conduct? How are you relying upon, what facts are you relying upon to reach the conclusion that currently, right, they don't suffer from substance abuse issues? So eventually you'll end up in court, right? You'll file a request for order. You'll end up in court. Maybe you'll do the step up. And you should not expect the court at the initial hearing to let go of the testing, meaning whether or not you've voluntarily been testing, At that point, the judge will probably exercise the right under 3041.5 of the family code to say, thank you very much for admitting, right, to a history of habitual, right, or continual use of alcohol or controlled substances. I appreciate the fact that you're owning up to it and you've cleaned up, but I'm told that substance abuse is, people sometimes slip, right? They'll clean up and then they'll go right back into it. They'll have a traumatic event in their life and it'll start all over, right? They'll go back to abusing drugs. So typically the court will put certain controls in place as a condition to you having that visitation, right? For example, I like the expert you brought in, dear mother who suffers from substance abuse issues. I am ordering that that expert stays on board and I want reports from the expert. I want you to continue independently testing. And maybe your history is so bad that even though you're getting tested, I might put you even on monitored visitation at the beginning, just in an effort to make sure that everything is okay. The counter argument to that is going to be, why do I need to be on monitored visits if the issue at hand is not abuse of a child or of the other spouse? It's not domestic violence. It's abusing myself, which I've already cleaned up and I've proven up. So how is an uneducated, and I don't mean that in a bad way, but how is a non-expert monitor from a court-approved list who might be a retired bailiff, right? How do they have any expertise to ensure that I am safe, right, around the child? How does that really fix the issue? If I'm regularly testing, what's the problem? Maybe the judge will say you need to be on something like SoberLink, right, where you rent or purchase a device and you blow at certain points in time into it. Footnote, SoberLink is not 100% accurate. That too creates all sorts of problems when the judges assume that it's always accurate and you have a false positive. And now the judge says your visitation cuts off if you test positive. Now you have to come back to court and prove up that you're clean,
Yeah, in
right?
fact, I was retained almost once, and I was too busy to give the judge a testimony of interpreting the limits of testing the mathematics behind false negatives, false positives on sober
Yeah.
linking. Yeah, sure.
Yeah. So that's typically how I would approach it, right? You just make sure that you, by the way, I presented to you the side of the person that comes to me and says, I have a problem, right? Or maybe
Right.
they don't, but I start asking enough questions and I see that there is a problem, right? Meaning they don't admit to the problem, but asking them enough questions, gathering data from that client leads me to believe that there might be an issue, right? Then I think it's my obligation to bring it up and say, what's going on, So, anyway, obviously, if you represent the other side,
Yeah.
so now a parent comes in and says, my spouse has substance abuse issues. Response, how do you know? You're not an expert. What are you basing that on? Well, let's say it's alcohol, actually. That's a little easier, right?
Yeah, let's
They
keep it to
can,
alcohol.
yeah, alcohol. I mean, most lay people are going to, um, I would trust the client's judgment to tell me they're having so many drinks a day. They are, again, incoherent. They've had DUIs, things like that, right? So if there's enough of that, then we have to ask ourselves, is that behavior, number one, domestic violence? Again, because I'm determining what is the vehicle that I'm going to use to represent the client. Client comes to me with problem. Problem, my spouse abuses alcohol. How do I go about getting custody? All right. Well, is that spouse's behavior, does that behavior equal domestic violence? And we gather data. I call that homework for my clients. But everybody that comes into my office, if they hire us, I believe that good lawyers should always have a plan, a strategy, right? So once we're retained, we gather data on each issue pertaining to the case. In this case, we're talking custody, right? So the client is going to get what I call best interest homework, where we will gather best interest homework. The client is going to get domestic violence homework if I think that there are domestic violence issues, right? So if I gather enough, when I gather the information, the query is going to be, does the abuse of alcohol by the other spouse equate to domestic violence? Did that destroy the mental calm of my client? If it's a solid enough case for domestic violence, then I might recommend the client actually the opening move to be a request for a restraining order. If I don't think that the alcohol abuse by itself is sufficient for, domestic violence filing, right? Then we're talking about filing a regular request for custody, right? An RFO for custody. But then within that RFO, what are we going to ask for, right? Well, we're going to refer to 3011. We're going to refer to 3041.5 and say, Judge, here is the evidence that we have to show you by preponderance of the evidence that there is a history, right, of habitual, frequent, or continual illegal use of controlled substances or, again, abuse of alcohol. And if we can prove that up, the idea will be to get the judge to order the testing, right, at the time of a hearing. And until such time that testing has been ordered, until such time that the issues that we believe exist with the other parent have been addressed and managed, then probably the initial request is going to say, at best, monitored visitation, right? Maybe you throw in sober link, but again, you have to limit the amount of time that that parent spends with the child or children until those issues are addressed. So it might actually be an emergency filing, right, for custody orders, but it's not going to be a restraining order if there's not enough evidence for a restraining order. Then we're going to talk about things like, preserving evidence. So I'm talking, typically people who abuse these things are going to have some indicia, some proof of that abuse around the house right after they've left. Photographs of bottles, right? Maybe photographs of the nightstand that has all the fentanyl they were abusing or whatever prescription medication they might have been abusing or drugs, cocaine, whatever. Start documenting, right? So you start documenting. Social media, going under social media to save that photograph, that video that they put up. Identifying friend witnesses that might be willing to come in to prove up that habitual or frequent use. You'd be surprised, the opposing party's parents sometimes end up being our witnesses because they love their child, but they ultimately are objective enough to know that their child needs help. And so they can't think of any other way than to support the opposing party to get an order from a judge to force their child, their own child, to undergo testing, right? Because their child is not owning up to the problems that the child has.
No, yeah. And I've seen all of those things, and at times I've been retained to it. We'll wrap this up soon. There's everything you say actually opens up a can of worms that I just really want to dig into, and that just might be me. But I want to say this, and you tell me if I am incorrect. Hearing you discuss this stuff, having had some professional personal exposure with the legal system, I would say one of the challenges is going to be whether it's someone using drugs or a parent coming with an allegation in these separations. I think one of the things that people don't understand is the fact that their life, their emotion, their views, whether it's subjectively true only or has objective applications, you have to take that, process it through your cognitive professional bearings, and translate that into a framework that the legal system has to offer you. And I think that's an area that people have a hard time digesting often.
Right.
Would you say that's a good description of what you deal with every day?
Yeah, I agree. I mean, you're given a fact pattern, right? You're making sure that you get enough of the story, right, to understand the totality of the picture, right? So the client gives you usually just pieces of the puzzle, and you try to get the totality of the puzzle to understand what's going on. And then you have a limited number of tools. that you can try to use to prove up, right, their concerns and get remedies to address their concerns. I mean, look, judges are looking for solutions. When we go in front of judges as lawyers, we sit there and complain or, point the finger at the other parent or the other lawyer. But at the end of the day, the judge is looking for somebody that says, what's your solution? Tell me what I can do to help you, and tell me what allows me to do what you're asking me to do, right? Help me understand this puzzle, fine. But ultimately tell me, what is your solution to fix this? And how does your solution balance everything at hand? And how does your solution convince me that you're ultimately not trying to be punitive? We're again talking custody, right? You always have to remember that ultimately, this is not about punishing the other parent. We did say best interest, right? And it's not the best interest of mommy or daddy or, it doesn't matter if you're same sex couple. It's not the best interest of the parents. It's the best interest of the child. So it's not so much about even a judge who absolutely despises one of the parties. I've had a judge tell me once, I despise your client, but I have to remind myself that my job is not to punish your client. My job is to come up with something that is in the best interest of this child. So as much as I want to punish your client, I have to ask myself, does punishing your client achieve the best interest of that child? So when you think about it that way, regardless of what side I'm presenting, the solutions that I try to pitch and offer to a judge ultimately try to prove to the judge that we want to provide a light at the end of the tunnel for the other parent, meaning that we will identify the problem. We will identify solutions, which tend to be more immediate things that we need a judge to do. But we always want to try to tell the judge, in most cases, we'll say this: I acknowledge the other parent loves their child. I acknowledge that no matter what their issues are, right, they deserve in some way, shape, or fashion to be involved. It could be monitored visitation. It could just be telephonic visitation. It could be FaceTime visitation. So we want the judge to know we're not coming in to punish. We're coming in to preserve the best interest of that child or those children. We're providing solutions for that. And we are telling the judge, should this other side meet conditions subsequent to the orders that you're about to make, judge, with the passage of time, with the right help that they're going to get, we support the idea of them being involved at some point in time in the child's life. Those are the types of solutions that judges are more likely to accept. People who come in without that perception and all they're focused on is, I want to punish and I want to take as much as I can right now, most judges don't react well to that, right? They can sniff that. They know what you're up to, right? And they might give you the initial orders that you want, but in the long run, that strategy won't work. So, so that's my thought process, right? So, any other questions, or are we done for today?
Well, we're gonna close up right now. I want to add to those out there. I think what you should take, that if you're the one suffering from substance abuse and dealing with this, I think what Navid laid out is that there is a way, there is a process, and I think the legal system, at least here in California, and I think probably, I'm not a attorney across the country, they lean on attempting to have both parents involved. And this is a great opportunity for you to have momentum, reason, and a push towards getting your life together, your children. I want to comment also that, Navid, what you deal with, and I understand all officers of the court, including the judges, for the most part, they're trying to do the right thing. But I do believe that the system doesn't, at this point, equip them with everything that needs to be in the complexity of the social disorder that we experience. And
Can I say one more thing?
yeah,
So this is a separate topic. We can dive on this a little further, but if someone takes the time to read Family Code 3041.5, because you just talked about if you're someone that suffers from these substance abuse issues, there's a light at the end of the tunnel and there's a way, right, to have that relationship with your child. What's interesting about a portion of 3041.5, it actually says that a positive test by itself, even if it's proven, right? So you're positive for a illegal substance or you're positive, let's say for, I don't know, abusing alcohol, whatever. A positive test by itself is not a grounds for the court to decide custody. Why? Because best interest involves the balancing of factors. So one thing on its own is not supposed to be the end of the discussion, right? You may have a positive test, you may have substance abuse issues, but there are other qualities as a parent that you might bring to the table that the other one doesn't. So again, if you can deal with your substance abuse issues, then there is something you can bring to the table that perhaps the other parent can't. One more thing to notice, most family law lawyers don't know this. How many times do we attach drug tests to declarations in court? Many times. So if I represent, let's say, the parent that doesn't have an issue, and I have evidence of a positive test, right? Maybe because we did a stipulation, we did an agreement, right? And that agreement provides that the parent that has an issue is going to regularly test, right? Assume for a moment the agreement does not authorize the disclosure of the test. The agreement just says, I will test and I'll provide you a copy. Further assume there's no court order that authorizes the dissemination of that test. Yet most lawyers don't even know this. 3041.5 provides for mandatory sanctions after up to $2,500 if you do an unlawful or unauthorized disclosure or dissemination of a positive test. Very interesting.
so
So
what's the value of getting the test unless if you write into the stipulation and we have the we are allowed to disseminate this as needed for further
exactly. That's the point, right? So if you don't have a court order that authorizes that disclosure, right, or an agreement that says you get to actually attach it to a declaration, the moment you publish that, right, because it's public knowledge, you file a declaration, anybody can pull that up saying a divorce, right? You've just exposed your client or yourself to sanctions. That's very interesting to me that they're trying to keep the testing confidential. By the way, another topic to talk about another day. You know how you can get an expert and the expert can do the testing, right? And you think to yourself, let's assume you go to court under 3041.5 and you're pointing the finger at the other parent, right? And you're going habitual use of controlled substance. And judge says, I agree. And judge says, I order an expert to be involved, right? And I order some form of testing. And you think you've won. You got a win. Well, who says the test is admissible?
really.
You want to start there? It's not admissible. It's hearsay. So for another day, there's a case called Sanchez. We refer to it as, a Sanchez objection, but basically an expert can rely on reliable hearsay, right? But case specific hearsay that is relied upon by an expert has to independently be admitted into evidence for the expert's conclusions to come into evidence. Translation, expert conducts testing. For instance, I know one of the experts in Orange County that the courts use often. This expert ships out the testing to a lab in Colorado. Okay, that's just the protocol, right? The doctor does not conduct the testing himself. He sends it to a lab, Call it a lab in California, doesn't matter. But the doctor doesn't do the test. The doctor orders the test comes back, or doctor orders the panels, test goes out, test is done, test come back. Doctor then interprets the tests, renders an opinion. That opinion doesn't come in unless the test results come in. So now I'm going to have to go find some lab guy, some person in a big company that conducted the test, the lab test, subpoena them to come into court, subpoena the testing itself, get that into evidence before I can get the experts' conclusions into evidence. Now, add the complication that the lab is in Colorado. California does not have subpoena power in Colorado. So that's another layer of problems. So depending on what side I represent, if we don't have an agreement to have the test go into evidence, or we don't have an agreement to let the experts' opinions come into evidence, I can create roadblocks to the admission of the experts' opinions.
So, are you finished on that? I'm gonna give you something on that you might find interesting. I was involved in it wasn't a high profile, but it was a huge litigation issues for corporate things. And in this case, there was a death involved, and it was post mortem drug testing. And they ran into a little issue like this, and I got called because I know by the PI that was working for that huge corporate entity, and said, "Can you deal with this and deal with the drugs and the post-mortem?" And so here's my answer to this kind of thing if I was dragged to court. In this case, I didn't have to get dragged to court. I wrote a 10-page report, and it worked out. Here's what I would say. Let's say you're talking about the same thing, and what you need is there are the guys that do the testing and they run those labs, the medical part of it, that's a pathologist, right? And there's different kinds of pathologists. Here's the thing with any kind of testing. Mathematically, based on Bayes' theorem, his evaluation of that test and what it means clinically, and we're talking about clinically here, is meaningless. Mine is meaningful. And the only way a test makes sense, and this is a little bit of voodoo, but it's no more voodoo than Schrodinger's cat in the box in theoretical physics. The only way a test, if you ordered a basic blood panel on me and things came back off, if you ordered it, neither you would be able to interpret it because you had no reason or no understanding of why you ordered a test. But the pathologist who ran the test, he can't make any comments on it either. He can describe the limits of what this test means, and those limits will not be attributable to my psychological or clinical disease interpretation. Only I can make that judgment, and that would be my argument.
But you see, Doc, this is just evidence. This is the evidence code. The idea is that you did not run the test. So you can't attest to the accuracy of the test. So you cannot attest to whether or not, for a fact, the hair follicle that was taken from me, that you took from me, the hair sample you took from me, was the actual sample that the pathologist used to run the panels.
Oh, that's
so you see, that's really the concept. So the concept is that we just want to assure ourselves that whatever you are relying upon, that you're interpreting, is reliable, it's accurate. And the only person to do that is the person who ran the test, right? They're going to say it's also a chain of custody issue, right?
Chain of custody. I was going to say, this is a chain of custody, it sounds like.
But there's also a hearsay issue. The bottom line is, right, most judges, like when I go to a judge these days and I ask for a 730, evidence code section 730 custody evaluation.
Can you tell the folks what that means? How you got to get an expert?
Well, first of all, evidence code section 730 is not limited to family law cases, right?
Yeah,
Think about it.
it's all across the board.
The concept is that if there is a particular area that a judge considers to be beyond common knowledge or frame, so if the judge feels as though here's an area that I, as the judge, would require an expert to be involved in to assist me in making a decision under 730 of the evidence code, either the judge on their own motion, so on their own, or by a motion filed by one or both sides, can say, I'm now appointing an expert under evidence code section 730. So the 730 expert works for the judge. It's the judge's expert. But the court system doesn't pay for the expert, right? In family law, one or both parties are going to pay. So in family law, we're talking about a privately compensated individual that is hired, say again, as a custody expert. By the way, in family law, you can also use evidence code section 730 to have a expert for finances, like a forensic accountant. So anyway, so in the custody realm, the court can order a 730 evaluation, right, to conduct a custody eval, which is a deep dive, basically on custody. You know, they'll do some mental health testing and make some recommendations. All the work that goes into 730 comes from so many different sources, right? This 730 is talking to mommy, to daddy, or to both parents. Depending on the age of the child, they might interview the child, right? They might even talk to law enforcement. They might talk to social services if allowed by the court. They'll rely upon all sorts of hearsay, right? Diaries that parents have prepared, custody essays that a parent might submit, declarations filed by third parties. They might even speak to therapists, right? Because people usually waive privilege when they go through a 730. So they're gathering information from all sorts of places that are by definition hearsay. They're out of court statements made for the truth of the matter asserted, right?
Wow.
So then judges will say, you want me to order a 730? You need to sign a Sanchez waiver. I am not going to order a test and go through months and thousands of dollars of testing for you to come in and say, nope, we don't get to use any of this, because every single thing, imagine, everything that expert relied upon has to be independently marshaled and admitted into evidence for the conclusions of the expert to
be valid.
become right. So, but just so you know, my policy is I still refuse to sign it. I still refuse to do Sanchez waivers as a
Why?
general rule, unless my client wants me to. Why? Because I think it's malpractice to agree to something you've never seen.
Brilliant. Navid, let
So,
me just
right,
real
I
quick.
mean, I understand the court's point. It makes a lot of sense. Why are we going to go through an exercise only to find out that later we may not be able to use it? I totally agree. But what if we go through an exercise and the results are really, really bad for my client? And I just agreed that it's already coming into evidence. So now the other side can blow up my client.
Whereas you could have, I just want to explain really quick to the view. Look, a 730 is like in family law, you know, Navi, it's like this. Let's say I come and say, look, she's absolutely insane and an alcoholic and she can't take care of this child. There's no really evidence of it. So a 730 would be to get an outside expert. And in family law, you know, I would, you know, let's say pay for it. And this person, who's usually a mental health person, comes in and may spend 2 weeks to 2 months, I don't know, and gather all of this evidence and bring it in. And the Sanchez thing that Navid's referring to is, if you think about it, when we're talking about a lab, it falls under hearsay and chain of custody. And even that is a problem. So now in the case of the 730, every little bit of information that expert gathers over 2 months would have to go through years and years. And so what Navid is saying, the judge usually says, you know what, let's just sign a waiver that whatever evidence comes in is going to be accepted. Navid is saying, I usually will not agree to that for X, Y, and Z, one of which maybe something comes in and it works against my client. That's what a 730 is in family law. Maybe in criminal and other law would be something like, well, I dropped the phone company, dropped the call. Is such a thing possible? So you're going to hire a communications networking expert to say, is that thing possible? That would be a 730 in another area. Is that correct? Is that correct?
Yeah. Yeah. So, I mean, ultimately, though, if a judge says, I'm not ordering it unless you agree to a Sanchez waiver, that's the client's decision, right? So you pull your client to the side, you have a confidential conversation. If the client is willing to take the risk of not knowing what that 730 is going to say, then you go ahead. By the way, there are people you can hire to um, test your client for a 730 before through 730. But I've also been told by 730 evaluators that they can sniff that out. So they've told me, I remember attending a seminar where 730 told me, look, I've done this for 40 years. You don't think I know who these people go to get ready for my tests? You don't think that I can determine who has been trained to try to respond to my questions in a particular way? And you don't think that if I think that they're being mechanical or trained in answering certain questions, that I'm not going to point that out to the court or perhaps not give as much weight to certain responses? So there's pros and cons, right, to prepping for 730. But I still tend to think that it's best that before you go through a process, you educate yourself on it. So at minimum, you should probably speak to somebody that does 730 evaluations before you agree to one, just to understand the process and the type of testing you're going to go through, right? So that you can have some idea of how you're going to test. Because you might be trying to prove up that the other parent has a problem when in fact it ends up blowing up in your face, right? So, anyway, that's a topic for another day.
So there's so much for us to do here. I'm hoping on the next thing, hopefully you come join us again. So that's Navid Moshtael, the principal at Moshtael Law Firm. He practices in Orange County. I'm going to have his stuff on the bottom here. Navid, do you take cases outside of Orange County, Los Angeles, San Diego, anywhere else?
Yeah, so we have an office in San Diego, but so the counties we cover are, yeah, so Orange County, LA, Riverside, San Bernardino, and San Diego. We have a little over 40 people total for our staff. It fluctuates on total lawyers, but typically an average of 15 attorneys, and probably from the 15 attorneys, five or more of us would be, litigators, right, who are going to be going to court, whereas the rest are going to be support staff. So, um, in any event, thank you for having me as a guest. And yes, hopefully we'll do it again.
Yeah, we'll put this on the bottom. And Navid, thanks again for coming. And let's get into more controversial stuff. Hopefully you come back. And thanks, guys, for watching. Leave your comments, questions below. Give us a like and subscribe. And Navid, I'll see you soon.
Okay, sounds good.